Hello, friends. We're here to examine how due process rights are being violated by this administration. I'm going to show you how all the shenanigans and charades and smoke and mirrors are working. And I'm going to focus on one particular case. This case is called Matter of AMZF. This was decided on April the 14th, 2026. My name is George Pappas. I'm an attorney at law and a former immigration judge. Ladies and gentlemen, I am appalled by this decision. It is the most disingenuous attack on due process that I've seen to date. And there's been some real doozies. But this one is all filled with all the shenanigans and trickery and smoke and mirrors. So let me give you an example of what's happening. This case was decided by the Board of Immigration Appeals, where it stated that respondents, immigrants, and immigrant proceedings do not necessarily have a right to have their attorney provide a closing argument to defend their case, to apply for asylum or cancellation of removal or even adjustment of status. Ladies and gentlemen, the closing argument is where the attorney shines in defending zealously their client's case. This is where the attorney has the opportunity, after presenting evidence, after presenting testimony, direct exam, redirect. The closing is where everything is crystallized. It's where the attorney has a last chance to show the judge, in this case the judge, what evidence should be weighed heavily, what evidence should be not seen as material or as important, basically shaping the crystallization, the summation. To exclude that closing argument hits at the heart of due process. And why is this administration fighting to undermine due process? Well, they want to speed up the immigration hearings. If we can get rid of closing arguments, the deportation machine can close out cases even faster. And if we can remove the old closing argument, it weakens perhaps the case for the immigrants, making it easier to deny their relief, making it easier perhaps to even deny their appeals. But let me show you how this particular decision hides the ball in terms of what's fair and what's not fair. So I'm going to read a section here which really is at the heart very troubling. This is what the board says. The board is authorized to consider certain constitutional issues, and we routinely consider constitutional issues such as whether the actions of an immigration judge deny due process to a respondent. Here's what the board says. An applicant's fundamental due process rights are not violated when an immigration judge pretermits an application for asylum or related relief or protection if the applicant was afforded procedural rights and the applicant or his legal representative did not in writing or orally show prima facie eligibility for the relief or protection sought. Well, that sounds fair. If you don't produce enough sufficient evidence, what they're saying is that we can deny your case even without a hearing. And here is where they're hiding the ball. That pretermission memo was written in April of 2025 by former acting director Cersei Owens. And what she told judges like me is that you, for the sake of efficiency, can deny cases which on their face don't seem to satisfy, say, asylum requirements for relief. What that memo did not say is that we have an obligation to give the respondent an opportunity to rectify any defect in that so-called prima facie problem, in that sector of examination where there's not sufficient evidence. In other words, if we see that an application on its face is insufficient, the Executive Office of Immigration Review was telling us, pretermit, you don't need a hearing, issue removal. But other memos cited by the Executive Office of Immigration Review mandate that we give the immigrant, the respondent, a chance to rectify that defect. So what appears to be here a very fair-minded procedural argument that says if something is prima facie weak, you can deny the case and no closing argument is required. So that's myth number one, that the judge can pretermit if there's a lack of prima facie evidence. What that statement neglects to say is that the government, the judge, according to the Executive Office of Immigration Review in another memo, has an obligation to let the respondent have an opportunity to rectify that. So that would be a clear violation of due process. But what they're slipping in here is saying that that prima facie or insufficient evidence is enough to tell the judge that there's not enough here, I can dismiss and I can remove and I can order the person deported, contrary to the Executive Office of Immigration Review's own memos. Here's another one. Quote, declining to allow a closing argument after extensive testimony and argument is within the judgment's broad authority. How do they base that broad authority? Let's listen further. The Fifth Amendment's due process clause does not mandate that respondents be allowed to make closing arguments. So they're saying the Fifth Amendment does not mandate, doesn't necessarily say you have to have closing arguments. Hold on to that. Okay, listen to the next comment. In immigration proceedings, the right to due process is satisfied if the hearing is fundamentally fair. Well, today, immigration hearings are not fundamentally fair, which is even more reason why those closing arguments are critical to protecting Fifth Amendment due process rights. So they've slipped in the assumption that immigration judges can close off closing arguments if hearings are fundamentally fair. Removal proceedings, they say, must be conducted according to the standards of fundamental fairness. Well, ladies and gentlemen, here's the problem. Today, immigration hearings do not promote fundamental fairness. The June 27th memo by Acting Director Cersei Owens threatened judges that if they ruled in a certain way, they should get a different career or they'll be fired. This was an intimidating memo. That does not promote fairness. This administration has fired over 110 judges without cause. Don't you think that sends threatening messages to judges on the bench today? 3, that threat directly and indirectly does something else. It creates a financial interest that judges know that if they rule in an adverse way, contrary to the policy of the White House or this government, the White House, they'll be fired. Well, they just fired 6 more judges last week. Ladies and gentlemen, these are not fundamentally fair hearings. Judicial interference is being directly manipulated by this administration. I was told in May of this year, when ICE was roaming the courthouses, that I should grant motions to dismiss when the government asked for this. Well, what does that do? If I granted those motions to dismiss without looking at the merits, the individual's case would be dismissed. They would then walk out the courtroom, they'd be handcuffed, and they would be marched off to detention. What's wrong here? The judges are being told how to rule in specific cases. Another example of why these hearings are not fundamentally fair. It's another reason why closing arguments must be demanded in immigration courts, because the assumption that they're slipping in here, the Board of Immigration of Appeals, is that immigrations are fundamentally fair. They are anything but fair. That's another reason why this ruling is a ludicrous disgrace and undermines due process under the Fifth Amendment, because the hearings in immigration courts are not fundamentally fair. To then add insult to injury and tell respondents to their attorneys they don't have a right to a closing argument is appalling, absolutely appalling on its face. In matter of AMZF, this is the most disingenuous ruling that I've seen to date. There's others that are bad, but I thought I'd talk about this one. Let's keep this going, ladies and gentlemen. We'll keep exposing the fraud that is being masqueraded as due process in immigration courts. Have a good night.